3 days before the Homeowners Association tried to fine me into submission, I was standing knee-deep in mud, repairing an old fence line my grandfather built sometime before Elvis ever recorded a song. By the end of that same month, their president would be sitting in a courtroom trying to explain to a judge why her entire community had spent nearly 20 years operating on land they didn't actually control. The crazy part is, none of this started because of money. It started because a few people got so comfortable with authority that they forgot authority and ownership aren't the same thing. My name is Grant Holloway, and I own a ranch called Cedar Run Point on the north side of Lake Ashford. It's not some giant cattle empire, just enough land to keep me busy and enough history to keep me attached. My great-grandfather bought the original acreage back in the 1920s, and every generation since then added a little more to it. The place isn't fancy. The fence is lean. The barn complains every time the wind blows. Half the equipment looks like it belongs in a museum. But it's home. Most mornings follow the same routine. Coffee first, then chores, then whatever emergency the property decides to invent that day. That Tuesday started exactly like that. I had just finished replacing a cedar post near the eastern shoreline when I heard tires crunching down my gravel drive. I looked up expecting maybe a delivery truck or one of my neighbors. Instead, a black luxury SUV rolled to a stop. The kind of vehicle that somehow manages to look expensive and judgmental at the same time. Two people stepped out. A man in a pressed blue button-down shirt and loafers that had clearly never seen dirt before, and a woman carrying a tablet who looked like she regretted every decision that had led her to that moment. The man smiled. Not a friendly smile. A corporate smile. The kind that arrives 5 seconds before bad news. "Mr. Holloway?" he asked. "Depends who's asking." He chuckled like he'd practiced that reaction in a mirror. "My name is Derek Whitmore. I'm with Harbor Ridge Community Association." That got my attention. Harbor Ridge was the upscale lakeside development bordering part of my ranch. Big houses, fancy docks, golf carts everywhere. The kind of neighborhood where people held committee meetings about mailbox colors. Derek handed me a thick yellow envelope. "We're here regarding several compliance concerns." I remember looking at the envelope, then looking at him. "Compliance concerns?" "Yes, sir." Then he started talking. "Unauthorized fencing, visual obstruction, property maintenance deficiencies, landscape inconsistency, architectural nonconformity." Every sentence somehow sounded more ridiculous than the one before it. I kept waiting for him to laugh. He never did. The woman beside him stared at her tablet, like she wished she could disappear into it. Finally, Derek pointed toward my barn. The same barn that's been standing there since Harry Truman was president. That structure has become visually disruptive to the surrounding community image. I actually laughed. I couldn't help it. The words were so absurd they slipped past irritation and landed directly in comedy. But Derek wasn't joking. Not even a little. He continued listing violations while his loafers slowly sank into the mud. And that's when my grandfather's voice popped into my head. He used to say, when somebody starts talking too much, stop interrupting. People reveal more than they intend when they think nobody's challenging them. So I stayed quiet, and Derek kept talking. He mentioned escalating fines, enforcement actions, property impact concerns, potential remedies. Then one sentence caught my attention. Failure to cooperate may result in actions affecting adjacent and affiliated properties. Affiliated properties. That wording bothered me. Not because it sounded threatening, because it sounded ambitious. A little too ambitious. Eventually, they climbed back into the SUV and drove away. I stood there holding that envelope while dust settled across the driveway. Something felt off. Not scary. Not dangerous. Just wrong. The kind of wrong that makes the hair stand up on the back of your neck. 20 minutes later, I was sitting at my kitchen table reading every line of that notice. Most of it was legal-sounding nonsense. But underneath all the polished language, one thing became clear. These people believed they had authority over land that wasn't theirs. And as I stared out the window toward the lake, watching rain clouds gather over the water, I had a strange feeling that Harbor Ridge wasn't just overstepping. I had a feeling they were standing on a problem so large they didn't even know it existed yet. And buried inside an old filing cabinet in the back room of my house was the document that was about to turn their entire world upside down. I hadn't opened that filing cabinet in months, maybe longer. It sat in the back room beside a workbench covered in old tools and coffee-stained manuals. One of those heavy steel cabinets built back when people expected things to last forever. My grandfather used to keep every document imaginable. Tax records, surveys, leases, handwritten notes, receipts from tractors he'd sold 30 years earlier. As a kid, I thought he was obsessive. As an adult, I realized he understood something most people don't. Land isn't protected by fences. It's protected by paperwork. I spent the next hour digging through folders until I found what I was looking for. A green file tabbed simply, Ashford Lease Agreement, 1988. The paper was yellowed around the edges. The signature ink had faded slightly over the decades. But everything was still there. Every word, every clause, every condition. Back then, a developer named Walter Grayson had approached my grandfather about building Harbor Ridge along the lake. My grandfather didn't want to sell the land outright, but he agreed to lease a commercial parcel near the entrance road. It seemed like a reasonable arrangement at the time. The developer got access. The family kept ownership. Everybody won. At least that was the idea. I sat at the kitchen table reading through the agreement line by line. Most of it was standard legal language. Maintenance responsibilities, utility easements, access requirements, insurance provisions. Then I reached Section 7, and everything changed. Any transfer, reassignment, conveyance, or modification of occupancy rights under this agreement shall require written acknowledgement and consent from the Holloway Family Ownership Trust. I read it twice, then a third time. The clause had actually been underlined in blue ink by my grandfather himself. That wasn't normal. My grandfather only underlined things he expected someone to ignore someday. I leaned back in my chair and stared at the ceiling, because suddenly the entire situation felt different. The HOA letter, the threats, the talk about affiliated properties, the confidence, all of it felt built on an assumption. And assumptions have a bad habit of collapsing when somebody starts checking records. The next morning, I called the one person I trusted with land disputes. Attorney Marcus Hale. Now, Marcus wasn't flashy, didn't drive a luxury car, didn't wear expensive suits. Half the time, he looked like he had just wandered out of fishing cabin. But he had spent 30 years destroying bad legal arguments. That made him useful. After I explained everything, he was quiet for several seconds. Then he asked one question. Have you checked the assignment history? No. Do that before you answer another letter. What are you thinking? I'm thinking people usually get arrogant when they stop reading old contracts. That answer stayed with me. Over the next week, Marcus helped me request every available county filing connected to Harbor Ridge. Transfers, assignments, recorded amendments, tax documents, corporate filings, everything. Most people imagine legal investigations as dramatic moments with detectives and secret meetings. The truth is usually far less exciting. It's coffee, printers, highlighters, and long stretches of staring at documents until your eyes hurt. A week later, the record arrived. 36 pages. I spread them across my dining room table. At first, nothing stood out. Routine paperwork, corporate restructuring, administrative updates, the usual bureaucratic clutter. Then I found a document dated 2003. Assignment of operational rights. My stomach tightened immediately. I started reading. The original development company had transferred management authority to Harbor Ridge Community Association. Perfectly normal. Developments do that all the time. There were signatures, notary stamps, county recording numbers. Everything appeared legitimate until I reached the final page. Then I froze. No HOATried signature. No family trust acknowledgement. No written consent. Nothing. The one requirement specifically listed in Section 7 had never been completed. I checked again. Still nothing. I compared every page. Nothing. The transfer had happened anyway. For nearly 2 decades, the HOA had operated as though the assignment was valid. Maybe nobody noticed. Maybe nobody cared. Or maybe everybody assumed someone else handled it. Either way, there it was. A legal crack running straight through the foundation of their authority. I called Marcus immediately. He listened quietly while I explained what I found. When I finished, he asked me to bring every document to his office the following morning. No excitement, no celebration, just that, which somehow made me even more curious. The next day, I arrived carrying 2 banker boxes filled with records. Marcus spent nearly an hour reviewing everything, page after page, document after document, occasionally making notes, occasionally shaking his head. Finally, he walked over to a county parcel map hanging on the conference room wall. Then he pointed. Grant. Yeah. You see this shaded area? I nodded. That's the lease parcel. Okay. Now look at everything inside it. I studied the map, the community office, the meeting hall, maintenance building, parking lot, storage structures, every major HOA facility, every single one. Marcus folded his arms. They're not just operating on your family's land. He paused. They're entirely dependent on it. The room suddenly felt very quiet. For the first time, I realized the scale of what we were looking at. This wasn't some technical paperwork mistake. This was the foundation beneath the entire organization. Marcus turned toward me. If a court decides that assignment was defective, Harbor Ridge could have a very uncomfortable conversation about its legal standing. I laughed. That's lawyer language, isn't it? It is. What does it mean in normal English? It means they're standing on ice they think is concrete. For a moment, neither of us spoke. Then Marcus said something that would prove incredibly important later. Document everything they do from this point forward. Why? Because people who think they're untouchable usually make mistakes once they're scared. Turns out he was exactly right. 10 days later, another certified letter arrived. The fines had increased. $400 had become $1,200. The violation list had doubled. Now my machine shed was supposedly hazardous. My fencing threatened neighborhood aesthetics. My driveway required compliance review. My driveway, nearly half a mile away from their nearest boundary. At that point, I stopped being annoyed. I became curious, because nobody pushes that aggressively without a reason. Then my neighbor Diane Mercer dropped by one afternoon carrying homemade blackberry jam and enough information to change the entire story. Diane lived inside Harbor Ridge. She knew everybody, and more importantly, everybody trusted her enough to talk. We sat on the porch drinking iced tea while she casually mentioned something she'd heard during a recent community board meeting. Future expansion plans, additional parking, storage facilities, new entrance improvements. I listened quietly, and she mentioned where they hoped to build them. The western side of my ranch. 40 acres of untouched lakefront property. Land I had never offered for sale, never discussed selling, never negotiated over. Suddenly everything clicked into place. The fines, the pressure, the aggressive enforcement. This wasn't about compliance. It wasn't about fences. And it definitely wasn't about property values. It was about leverage. Someone wanted my land, and they were building a narrative to justify going after it. I stared across the pasture toward the lake. A cold feeling settled in my chest. Not fear, recognition, because now I finally understood what game they were playing. What I didn't know yet was just how badly they were about to overplay their hand. The first sign they were panicking came from a source I never expected. Not a lawyer, not a judge, not even a board member. It came from a landscaping crew. About a week after Marcus sent formal notice to Harbor Ridge regarding the defective assignment, I heard another truck coming up my driveway. This one pulled a trailer loaded with commercial equipment. Mowers, trimmers, edgers. 3 workers climbed out looking confused before they even reached my porch. The foreman held up a clipboard. We've been authorized to perform corrective maintenance. Authorized by who? Harbor Ridge Community Association. I almost laughed. Almost. Instead, I asked to see the paperwork. There it was. Official letterhead. Work order number. Authorization language. Instructions to enter my property and remedy compliance deficiencies. I pointed toward one of my security cameras. Sir, before you do anything else, I need you to understand that you're standing on private property and everything happening right now is being recorded. The poor guy looked like he wanted to vanish. Within 15 minutes, the truck was backing out of my driveway. Nobody touched a single blade of grass. When Marcus saw the footage later that afternoon, he smiled for the first time since this whole thing started. Grant, he said, people usually try to hide evidence. These folks keep delivering it. But that wasn't their biggest mistake. 3 days later, Harbor Ridge officially filed suit against me. According to their complaint, my property was negatively affecting community standards, damaging neighboring values, and interfering with future development objectives. Future development objectives. There it was. The mask finally slipped. They weren't even pretending anymore. When Marcus finished reading the filing, he leaned back in his chair. I shook his head. They just opened discovery. I wasn't a lawyer. That didn't mean much to me. Is that good? It's fantastic. Why? Because now we get access to everything. Every email, every board discussion, every internal communication, every meeting record, everything. The counterclaim Marcus filed was nearly 50 pages long. It included trespass, defamation, impropriété surveillance, abuse of process, fraudulent assertions of authority. And at the center of it all sat the defective assignment agreement from 2003. The hearing was scheduled for July, and by the time it arrived, the entire county seemed aware of the dispute. On the morning of the hearing, I parked across from the courthouse and sat in my truck for a few minutes. Not because I was nervous, because I was thinking about my grandfather, the man who had signed that original lease decades earlier, the man who underlined Section 7, the man who somehow saw this possibility long before any of us did. Then I walked inside. The courtroom wasn't large. A few rows of seats, old wood paneling, an air conditioner that sounded like it was losing an argument with itself. The Harbor Ridge board sat together across the aisle. Their president, Veronica Shaw, looked as polished as ever. Perfect suit, perfect hair, perfect posture. But something had changed. For the first time since this started, she looked uncertain. Their attorney looked worse. Much worse. The confidence he displayed in previous correspondence had evaporated completely. When Judge Eleanor Price entered the room, everything became very quiet. She reviewed several documents before looking directly at Harbor Ridge's attorney. Before addressing enforcement authority, she said, "I would like clarification regarding jurisdiction." That single sentence changed the atmosphere immediately. The attorney stood and delivered a polished argument. Community interests, property values, statutory authority, neighborhood protection. It sounded impressive for about 10 minutes. Then Judge Price turned toward Marcus. "Mr. Hale." Marcus stood, walked to the podium, and placed exactly 3 documents in front of the court. The original lease, the assignment agreement, the parcel map, nothing else. No theatrics, no dramatic speeches, just paperwork. "Your Honor," he said calmly, "the petitioner seeks authority over land that has never been subject to its governing covenants. Furthermore, the facilities from which the petitioner operates appear to occupy property under an assignment that failed to satisfy mandatory transfer requirements contained within the original lease agreement." Then he displayed the parcel map. Every major Harbor Ridge facility lit up on the screen. The office, the community center, the maintenance building, the parking lot, all of it, every square foot, sitting on Holloway-owned land. The silence inside that courtroom felt enormous. Judge Price studied the map for several seconds. Then she looked directly at Veronica Shaw. "Ms. Shaw, were you aware your association's operational facilities are located on property owned by Mr. Holloway?" Veronica immediately turned toward her attorney. The attorney looked down at his notes. Nobody answered, and somehow that silence answered everything. Finally, Veronica cleared her throat. "We relied on the validity of the existing assignment." The judge nodded slowly. "Without reviewing the underlying lease conditions?" No answer. Another silence. Longer this time. I remember watching that moment and realizing the entire case had just collapsed. Not because anyone admitted wrongdoing, because they admitted they never checked. The ruling came less than an hour later. Every fine dismissed. Every enforcement action suspended. Immediate injunction against further attempts to regulate my property. Additional review ordered regarding the assignment itself. When the hearing ended, Veronica remained seated for several moments, almost as if standing up would somehow make everything more real. Outside the courthouse, reporters gathered around both legal teams. Marcus delivered exactly one statement. Authority requires a legal foundation. confidence is not a substitute. That quote appeared in the local paper the next morning. And honestly, it summarized the entire situation perfectly. Settlement negotiations dragged on for nearly 2 months. In the end, Harbor Ridge agreed to pay legal fees, compensation related to the trespass incident, damages associated with the surveillance issues, and a public statement correcting their claims. But the biggest consequence involved the lease itself. The court ultimately concluded the original assignment had indeed been defective, which meant Harbor Ridge needed an entirely new agreement if they wanted to remain where they were. This time the terms were very different. Higher lease payments, strict limits on future expansion, mandatory disclosure to all residents regarding the land ownership arrangement, additional legal protections, and significantly stronger termination safeguards. Veronica Shaw resigned before the new agreement was finalized. Officially, it was for personal reasons. Unofficially, several board members had already demanded answers about how the association nearly lost control of its own facilities. A few months later, I found myself back where the story started, repairing fence posts near the shoreline. Same lake, same wind, same old barn. The only difference was perspective, because after everything that happened, I realized this was never really a story about an HOA. It was a story about human nature, about what happens when people become so comfortable with power that they stop questioning where it comes from. Some Harbor Ridge residents still blame me. Even now, they say I embarrassed the community, created conflict, made things harder than they needed to be. Maybe they're right. Or maybe standing up for your rights always looks inconvenient to people who benefit from ignoring them. I honestly don't know. What I do know is this. My grandfather used to tell me that ownership rarely disappears overnight. It disappears one signature at a time, one assumption at a time, one unchecked document at a time. And if nobody pays attention, eventually people start believing something belongs to them simply because they've been acting like it does. So now I want to ask you, if you lived inside that community, whose side would you have taken? Would you support the HOA's argument that they were protecting property values and future growth? Or would you stand with the landowner defending rights that were legally his from the very beginning? And here's the bigger question. At what point does community leadership stop being protection and start becoming entitlement? Drop your thoughts in the comments below, because I can promise you one thing. This debate is a lot less simple than most people think. If you enjoyed this story, make sure to like the video, subscribe to the channel, and share it with someone who has strong opinions about HOAs, property rights, or small-town power struggles. I'd love to hear where you stand on this one.